Hello and welcome to your weekend morning brew, a more languid, laid-back, slow-listening podcast with me, your host, Shivraj Parshad. I'm hoping you will add us to your weekend playlist and give us a listen. On September the 6th, 2018, a 5-judge bench of the Supreme Court read down Section 377, liberating millions of lesbian, gay, bisexual and transgender Indians from a 160-year-old Victorian-era law. And then about 3 weeks later, the highest court struck down another Victorian law, criminalising adultery, then lifted a bar on women of menstruating age from entering the Sabarimala temple in Kerala. Judgments that expanded on issues of gender identity, sexual choice, and the dignity of every Indian. I present to you Sex and the Supreme Court with Saurabh Kirpal, a lawyer at the center of the argument against 377, and editor of that anthology of essays of the same name. And, I am proud to say, a close friend. Saurabh, it's really so good to connect with you on my weekend playlist.
Thank you for having me on, Shivraj, and I can't think of a better podcast than to be on rather than yours.
Thank you so much, Saurabh. Now, I read the book twice. What an expansive book. You bring together legal luminaries with their insights, lawyers who fought the cases with different perspectives, and critically, others, people like us, with personal narratives and accounts. But personally, Saurabh, for you, what was your purpose for putting this out?
Shivraj, I always felt that the lay person, when they read about the law in India, they get all their information from the media. And the media itself is not exactly legally literate, and certainly doesn't care to or purport to be legally literate. So there is, I think, a gap in the knowledge of the common person as to what exactly the court decides and the decision-making process and the impact those judgments have on the lives of people. So I really wanted to bridge that gap and to get people who have legal knowledge, so lawyers, judges, and very eminent people, to write about issues about sex, gender, and sexuality. Write it for the common person in a language that they could understand without dumbing it down too much, right? The idea is to present that what the court has decided and give it context in a legal framework, but also to have articles and essays written by people like Ritu and Zainab and Keshav and Namita, who are people who have lived through these experiences, that these judgments mean something to them. So I really wanted to give a context both to the legal aspect of these judgments and the impact they've had on people's lives. And as regards the choice really of the subject, I think, as you rightly said in your introduction, this was a case of a series of judgments which had come out at that point of time, which all related to sexuality, gender. Really, that was my idea, is to make something which is hitherto inaccessible to the person, to the layperson, accessible to them.
Yes, because when I reported on the courts, there's so much in all these judgments, there's so much content, it's very difficult to understand the impact. But what's really important is that the highest court in the last 5 or 7 years has really placed us, the individual, and not the state or other actors at the center of decision making,
Exactly.
right?
And that brings us to the issue of this book. When I talk about sex and the Supreme Court, we talk of sex in a very generic sense, right? Sex is not just, of course, the distinction between male and female and the normal idea of sexual discrimination. But this idea of sex really embodies a more important concept, the idea of the individual and the idea of the dignity of the individual, really. Because sex is then an attribute as well, which is mutable as well as immutable. So, for instance, the idea of sexuality forms very much part of sex. The idea of gender forms very much part of the sex. But at the end of this, what is it that we're really trying to do? We're trying to protect the constitutional rights that people have, and the constitutional rights people have ultimately all focus on the individual rights that a person has, right? The entire part 3 of the Constitution of India, the fundamental rights chapter, has one sole purpose: the idea to enable an individual to recognize to the fullest potential of their identity, the ability to live the life that they wish to live with dignity. So, in that context, it was important to talk about what is the distinction really between an individual and their dignity and the opposing force. And what the opposing force is: the force of the community, the force of religion, the force of the state. So, really, there is a conflict in our cases, and all these cases are an example of that, of a tug of war, really, between the rights that the individual claims for him or herself, be it sexuality or sex, and the contrary claims. Now, whether they're valid or not is another point, but the claims are nevertheless there by religious groups. For instance, in the Sabarimala matter, where the religious group says it is our right to forbid women from entering, vis-a-vis the right of the woman to say, no, I want to enter. So, in all of these cases, it was important that the judgment ultimately favored the rights of the individual as against the claims of the community. And that is really in consonance, I think, with what the Constitution of India also proclaims, which is that it pertains and puts the individual at the center of the constitutional firmament.
And the idea of dignity and autonomy is one of the major threads running through the book. But before we get down to how you bring that to us, it is important, I think, for my weekend playlist listeners to really understand who Saurabh Kirpal is. Tell us more.
I'm a lawyer who is a gay lawyer who's been practicing in the Supreme Court for well over 25 years. I've argued matters for people from across the ideological spectrum, people of the right, people of the left. So I suppose a lot of people on either side of the spectrum don't trust me, thinking that how could you have done that? I honestly believe that the duty of any lawyer is first to represent the client regardless of their ideology. And more importantly, I also believe that if we don't engage with the left or the right, then I think we lose a very substantial portion of the people we wish to convince and the people we wish to talk about and the people we wish to carry along. So I would like to say, a centrist gay lawyer. I've been living with my partner for 19 years. We live in Delhi in a joint family. Mummy and daddy live on the ground floor and the first floor. They very kindly allowed us to make our little love nest on the second floor. And in all ways, we're a good, proper, traditional Punjabi joint family. And that's who I am. And of course, I am the author and the editor of this anthology that I'm rather proud of, Sex and the Supreme Court, that you've talked so kindly about, Shivraj, and what we're talking about today.
Now, something that comes up in the writing is that often the deeply personal is also political. The courts may pass judgment, but it is another matter of societal norms or people catch up.
That which is deeply personal is, of course, political. And this brings us back to the idea of the public-private divide. Is that how I would see it? Is that the distinctions between the personal and the political are rather more tenuous than we'd like to think. For instance, in the idea of sexuality, when we talk of what is deeply personal, is a political idea. Initial arguments on the defense or which were raised before the High Court in 2009, which led to the judgment of the High Court striking down Section 377, was the idea that really a person should have autonomy and their personal private decisions should not be subject matter of the state and the state to interfere in their personal choices. But of course, that's not entirely true, because to be gay or to be a homosexual is also a political statement, because I don't want to be a gay person just in my bedroom. I want to be a gay person expressing my views, my ideas out there in the open, maybe making alliances with other oppressed groups, maybe people of the subordinate castes, women, whatever else. So really, the idea of the individual having their identity as defining them is very much tied in to the idea of their political persona and how they choose to project it. That's how I would really equate or relate that which is deeply personal with that which is political. Really, ultimately, people play out their lives in society, and these judgments have impact only when people are trying to live their lives. And the way the judgment of the Supreme Court, or even the guarantee of equality in the Constitution for women, is a dead letter unless it is accepted by society or accepted by culture and actually ingrained in society. It really won't have meaning. So I think there is some kind of a symbiotic relationship, really, between the personal and the political, between the judgment of the court and how society and culture changes it. Because you say also in your question, Shivraj, that will societal norms catch up to it? I think societal norms often do catch up because of the moral authority of the court. But since I'm talking of symbiosis, it's also the reverse. Sometimes the court takes time to catch up to what society thinks. And I think the 377 judgment was just one such instance. I honestly believe society had actually moved on in 2018 and was quite ready for 377 to have been done away with. And the court was 5 years late in recognizing that. So who catches up with whom? That's an open question.
I'm not going to beat around the bush, Saurabh, because you are an old friend. And I remember 2 years ago, you being offered a judgeship. And this is why I asked that question just before this. I know you've spoken to the press about this, but I want to hear directly from you. Why hasn't it happened? Is it because you are an openly gay man?
Well, the first thing I'll correct you on is that I was offered judgeship not 2 years ago, but 3 years ago. So the wait has been even longer, 3 years. Look, the problem with the appointment of judges to the higher judiciary in our country, and I must point out that I was asked to be a judge of the Delhi High Court, is that there is a concept of the collegium system where the senior judges sit together and decide as to what is or who is not worthy of being appointed as a judge of the High Court or the Supreme Court. And really, we don't know exactly what's going on in their mind. Having said that, India is a rather leaky system and nothing stays secret for very long. So in my personal case, the High Court recommended me without any demur. It was a consensus, unanimity between the collegium. The matter was sent to the Supreme Court. And the Supreme Court can take a decision one way or the other, right? They can say, yes, he's worthy of being appointed, or he's not worthy of being appointed. And that's exactly what happened with 8 of my other colleagues. So 9 names had gone simultaneously. And for the other 8, the decision was taken saying certain people are worthy of being appointed, and they were in fact appointed, and certain other people were not. But in my case, something rather more curious happened. The matter was deferred. Once, then it was deferred the second time, then it was deferred the third time. And it still lies deferred. So it's pending on the file of the Chief Justice of India and his 2 senior colleagues. And then in the press sometime later, an article came, and since then there's been a deluge of such media reports, that the reason for this deferment is the idea that my partner, who is a Swiss national, is a foreign national, and it is not possible, allegedly, for the government to find out his antecedents, etc. Even though, of course, he's been living in India for 19 years. And of course, the IB report also does mention the fact that I am a gay man. So that's not a secret either. And the media reports say that they found this out through Facebook and other social media of mine, which
That's so odd.
yes, we're required to disclose it in the form, by the way, your social media. And I did. I have nothing to hide. I've lived my life openly and freely. And I saw no reason that if I was going to become a judge, why I should hide that. That was never my intention. That was never my desire. I was accepting judgeship for the reason of seeking equality for the LGBT community, for the queer community. So there was no point in me hiding it. Now, if I were a straight man, I'd marry my partner, and then I wonder what they'd say, because really it's not without precedent that there's been a foreign partner for a Supreme Court judge. Justice Vivian Bose, one of the greatest judges of our Supreme Court, had an English wife. And our current foreign minister, Mr. Jaishankar, has a Japanese wife. So if that's not a security threat, then I don't see how my partner would be a security threat. I don't think there's any doubt in my mind, at least, that the real issue was the fact that I happen to be something other than a straight man.
And how does that make you feel, Saurabh?
At one stage, relieved and disappointed. Relieved because I do believe the task of being a judge is a rather tough one. I think we've become quite used to running down judges and criticizing them without understanding the pressure that they're under. They do a lot of work, a lot of good for very little money and with tremendous pressure on time. I think an average judge works 12 to 14 hours a day, probably more than any lawyer. So there was relief. Look, I accepted the offer to become a judge, not because I was dying to give up a rather cushy life as a lawyer, but I saw it as a social responsibility. I can't complain about inaccessibility to justice if I'm not willing to put myself out there, right? So that was one reason. But more importantly, I felt that as a member of the queer community, it was important for me to accept judgeship so that I could bring diversity to the bench and bring a certain empathy that I think certain judges at times lack. Equally, it was important, I thought, for the general public to know that it was possible to be a gay person and to be on the bench, and you'd be the same as anybody, if not better. And most importantly, for the queer community to have some kind of a member of their own community reach the highest, yes, absolutely representing them so they could feel pride in themselves, right? Because that is the biggest problem for the queer community. And that's why we have pride marches, is because there's a deep sense of shame everywhere. And if we need to fight against discrimination, we first have to address the demon of shame within ourselves. And one of those ways is to have people you can look up to. So therefore, there is disappointment that I could not have that opportunity to be that role model for the gay community.
Now, back to the book, Saurabh, and clearly you've structured it so well, and it all ties in with what you just said. In the first section, Sex in the Individual, you take up the issue of autonomy and gender identity by explaining the history of the LGBTQ community struggle. And we've discussed that already. And there's that fabulous essay by Justice Lokur on the transgender question, and then those personal narratives. It's in the next section, the question of personal choice. You elaborate on interfaith marriage. You bring in Khap Panchayats. Then there's that wonderful essay on adultery. But really, what shocked me here as a layperson was the extent to which we seem to have been okay with the paternalistic and patriarchal practices where women, and I never really understood this before I read the book, were seen as chattel with no personal agency.
Well, I don't think it should surprise you, because what you must remember is that all of these cases were dealing with the Indian Penal Code, which was drafted in 1860. So, what was the idea of women and the power of women and this patriarchal structure in 1860 has been frozen in the Indian Penal Code ever since. And that's what was applied even in 2020. So, it's really no cause of surprise as to that women were seen as chattel, because in England in 1860, and I don't think we can very proudly, even with our Hindu traditions, look back and say that women were given great place of power. If you read the Manusmriti or the Shastras, the women were not exactly liberated individuals who had all the rights. So if you have this structure of patriarchy and you compress it into a law or a penal code, and then you don't bother changing it for 160, 150 years, then obviously you will have a structure of law which is patriarchal. Now, of course, this simply reflects the patriarchy, which is systemic in our culture, in our law, and in every aspect of our being. So there is some kind of a interplay really between the structures of the law, which first engender patriarchy, then enforce it, and then perpetuate it, and society, on the other hand, which glibly gobbles this up. And the most telling example is, as you mentioned, the question of adultery. Now, what was the position on the law of adultery? The idea was that a man could sue another man for having had an adulterous relationship with his wife.
But not the reverse.
But not the reverse, yes. A wife could not sue her husband. The idea is very simple. The idea was that the wife was the property of her husband. And if another man comes along and sleeps with his wife, he is effectively impinging his proprietary rights over his wife, the sexual rights that the husband claims over his wife. And that's why there's a beautiful chapter by Menaka and Arundhati, Menaka Guruswami and Arundhati Karju in the book, where they take the idea of adultery and discuss how the idea of sexuality within marriage has been perpetuated really through the penal code, including the marital rape exception. right?
Exactly. I was going to come to that because they really talk about how the agency does not exist. And therefore, there's social morality versus constitutional morality, and public morality versus constitutional morality.
Absolutely. So, what is the idea of marital rape, and why is it not recognized as rape? Because there's a specific exception to it. Is the idea that women's sexuality within marriage does not exist any longer. It's one thing to say that a woman belongs to a man, which it clearly
Mm,
the law is implying here. So that a woman cannot be raped because you can't rape something that you own. That's one way of looking at it. And the other is basically the desexualization and consequently the dehumanization of women within the concept of marriage. And
mm,
so that's a deeply problematic. And you're right when you speak of constitutional morality and personal morality, is that when the court examined this, they
mm,
said that it doesn't matter what society wants. Maybe society is patriarchal, and of course,
mm,
society is. But in a fight between the idea of patriarch social morality versus the rights of the individual, what you called constitutional morality,
mhm.
surely the latter that will triumph. Because the courts
Right.
of law are not out there to enforce societal norms, societal ideas, but they're there to enforce and constitutional
Right.
ideals, right? So in that battle, it'll have to be undoubtedly the constitution that will triumph, as it has in all these cases.
Hmm. And what's very interesting is they make a call in that essay for social morality bending before values of equality and dignity. But then, sort of, we still have controversies like the Tanishq ad, where it celebrated a diversity and then was pulled down by such immense public pressure, arraigned against interfaith union. So, have we really progressed?
Well, obviously, we haven't, I think. You're right. This is something I alluded to earlier, that one judgment of a Supreme Court or even 100 judgments of the Supreme Court are not going to change society. Changing society is a very complex task and it will take its own time. Judgments do their bit, right?
Hmm.
Ultimately, however, we have to take that judgment, go as civil society members, and try to do our own bit to change society. I don't believe just like tweeting once in a while or moving the court once in a while is sufficient. We probably need to be out there in the streets sometimes, making our voice
Hmm.
heard. You need to go out there, see and be seen. You need to do that effort. You need to be an activist. But of course, not everyone can be an activist, Shivraj. And I think I'm being unfair if I expect
Hmm.
everybody to give up their day job and go to Jantar Mantar and sit.
At least like what I call myself. I say I'm not an activist, but I'm advocate. And that's what Namita Bhandari's powerful chapter calls for, right? A new deal. After detailing how the MeToo movement really blew the lid on the sexual harassment question, 30 years after a judgment made such a call for equality in the workplace, it is telling, isn't it?
Namita Bhandari's, I think, was probably one of the most beautiful chapters in the book. Vishakha was a judgment in the mid 90s. As you said, it took the parliament 25 years to enact legislation prohibiting sexual harassment at the workplace. And this is not something that is controversial. I can understand something like decriminalising homosexuality, which would be controversial in the 90s. Surely no one could say that protecting women at the workplace would be a controversial thing.
But it was born of a horrible and controversial incident, right, with Bhanwar Devi.
Abari Devi, yes, that was a case of a gang rape in Rajasthan,
Hmm.
which found its way up to the Supreme Court ultimately. And that's what led to that judgment in Vishakha's case being passed. And of course, I don't think Bhabri Devi ever got justice really. So
No.
that's another sad story, and that happens often. Is that while we get involved in our media, and for instance in the Hathras case and other cases, there'll be a few cases that will catch the public imagination, and we'll follow it. Maybe not always till the very bitter end. Some of the cases will be followed to the bitter end, but a lot will be dropped off.
Yeah, because public memory is so short in India. There's so much happening that is so wrong.
The idea is, and this comes back to what I was saying earlier, while we may not all be activists, we
Mm-hmm.
all have to be politically aware and
Mm.
politically attuned. And really, politics is not just a matter of voting every 5 years. It's also important to keep yourself aware and abreast of that which is happening in our midst and keep ourselves out of the echo chambers that we build for ourselves, the cocoons we build for ourselves. So
Mm.
we owe it to ourselves to make ourselves aware of the politics of the country. And that's why, to some extent, I
Mm.
wrote this book, The idea that people would be able to become citizens who can participate in their democracy, having some knowledge of what we're talking about, as
Yeah.
opposed to some gossip that they've picked up from here or there, or some tidbit that they picked up from some newspaper. So the New Deal that Namita talks of, it's absolutely imperative that it's about time that women get their due. This reminds me of a lovely quote of Ruth Bader Ginsburg when someone asked her that how many women do you think will be sufficient on the Supreme Court? And she said nine. Because we quite happily accept the systemic patriarchy and prejudice against women. We don't question it. In the Supreme Court today, there are only two women judges out of 34. The inequality is in our face for all to see. And yet, it's not a subject of discussion. The Women's Reservation Bill has been hanging fire for the longest time. Why?
My God, yes. When I was a young reporter, we were dealing with it in 94, 95, and it's just not come through. And, Saurabh, what I found incredibly tough, and I think that comes from what you said, you mustn't have a surface understanding, you must go in depth, was the penultimate section on sex and religion. From the judgment on triple talaq, the elaboration of the Indian Muslim law, and critique of the Sabarimala judgment, it is intense and emotive and intricate. Really a case of a clash of public morality with the court's view, right?
That's absolutely the case. I think these are particularly emotive issues, right? The clash between a society and homosexuality on the one hand and the views of the conservative majority on the other is one thing. But religion is a deeply, deeply personal thing, right? So triple talaq and Sabarimala both relate to religion. And as a society in India, we are a very conservative, but a very deeply religious society. It's something to take very, very seriously. So when you talk of rights and we suddenly start talking of religion, we start thinking of, oh, but what about the rights of the religion? And I must point out, this is the one instance where the Constitution departs from its normal instance of protecting individual rights. So Article 14, 19, 21, the right to equality, right to free speech and freedom and right to personal liberty are all individual rights. In matters of religion is the only time where communities, i.e. religious minorities in certain instances, have been given rights. Religious denominations have been given rights because the constitution makers realized that the kind of country we live in is a deeply religious country. And issues of religion, therefore, are inevitably very emotive. Because people feel that when you talk about religion, you are affecting not merely doing a social cause or you're talking of something else. People believe that you're talking to them. So when you are talking of reforming Muslim personal law by the abolition of triple talaq, members of the Muslim community will feel that you're attacking their religion. And of course, we live in a certain societal context now where that fear may not be unfounded, right? They may be justified sometimes in thinking, ignoring, of course, the great travesty and injustice that has been meted out to Muslim women, often by members of the majority community. So Shah Bano judgment, which is reversed by parliament, was done by a Hindu majority parliament, right? It wasn't done by Muslims. So Muslim women have been discriminated against not just by members of their own community, but by the majority community as well. But the point, as you said, is right. When there's something as deep as religion, the clash becomes more intense, it becomes more personal. But that's to be expected. And the same thing with Sabarimala. The idea of their faith, people believe that their faith has been defiled if a woman of menstruating age walks into their temple. People firmly believe that. There will have to be. And since I said that the Constitution protects rights of the community and rights of religion, I think sometimes we take an oversimplistic views of the fight between religion and the individual, always putting the individual above. I think in the case of religion and an individual, a more subtle balance, Shivraj, has to be drawn. Because ultimately, if you always put the right of the individual above that of the religion on the grounds of rationality, you're basically saying religion just isn't worth it anymore. Because religion is not always a rational set of beliefs, right? Religion is almost per se a matter of faith and hence beyond rationality. So if we had to start pitting individualism versus religion on some kind of a test of rationality,
We're on a slippery slope.
inevitably religion will lose. And the impact of that, of course, in the long term will be that
Hmm.
the religious rights that a minority has
Hmm.
will be completely done away with.
Hmm.
So I think a lot has to be said about a delicate balancing task.
Hmm. And I really hope people go through this section at least more than once, because it has such intricacy and details that we weren't even aware of. And I think Justice Sikri's ultimate chapter should be made compulsory reading for anyone, understanding why human dignity is the only measure to unshackle us, right, Saurabh?
Really, I think if there's one chapter which gives a idea of the underlying thread in the entire book, is the chapter on dignity by Justice Sikri. Because what he says is that ultimately what the court is aiming to do is to uphold the dignity of every individual
Hmm.
in drawing howsoever or whatsoever balance that it's trying to do. In the case of Sabarimala, or in the case of triple talaq on the one hand, in the case of the MeToo movement, in the case of 377 transgenders, all these issues are ultimately about trying to find the innate dignity, the innate humanity in the individual. Justice Sikri talks about Kant and Kantian philosophy. So those of you who maybe want a little primer in reading about Kantian philosophy can go and see what he says about the innate value of dignity. When we make a society where the dignity of every individual is recognized, appreciated, and the legal structures are such that we aim to maximize the dignity of each individual, we
Hmm.
end up with a better, more just, more humane, and a happier society, and certainly a society that I would like to live in, and I hope our children would like to do.
Now, returning to the issues that underpin the book, decriminalization of Section 377, what does the future look like? Is same sex marriage the next step?
Well, that's often a question that has split the queer community, I think. I find
Hmm. And that was going to be my next question, because, anti discrimination laws, protection rights for the more vulnerable. I think activists in the queer community say marriage is a privilege of a few and that these must come
you
first.
see, so to them, I'd say that activism, going to courts, it's not a zero sum game. It's
Hmm.
not that if you've had a lollipop today, yeah, my young child, you can't have the cake. I'm
Hmm.
sorry, I'm a gay person. I want that lollipop and I want that cake. So there's no point fighting and say that let's not have same-sex marriage. Let's ask for an anti-discrimination code. I don't see why we can't have both. Straight people have both, don't they? They have marriage and they have anti-discrimination codes. Why can't I? So
Right.
if that be the case, to come back to your question on therefore on same-sex marriage, is that the next thing? Well, it is the next thing, just as well, just the same way as I hope an anti discrimination code would be the next thing. And I don't believe it's correct for activists who say that marriage is a privilege of the few, right? See, now, activists oppose the concept of marriage on two separate fronts. One is that it's going to detract us from our focus, to which I've
Hmm.
already answered saying, no, we have enough bandwidth with us to look at both anti discrimination as well as same sex marriage. But there's a
Hmm.
more problematic issue that some people take with same sex marriage, the idea of some kind of heteronormativity that is innate in the concept of marriage and the
Hmm.
hierarchy that is innate in the concept of marriage. Well, the solution to that is to reform the institution of marriage, not to deny it to those people who have already been denied most other rights.
Right. And Saurabh, it's interesting because when you say that, as we speak, there are four different petitions now, right? Which are challenging different types of marriage acts at the High Court level in Delhi and Kerala.
There's one by Abhijit Iyer, which is pending in the Delhi High Court, which challenges the Hindu Marriage Act. More than challenge, I think he believes that the Hindu Marriage Act already allows Hindu people to get married. We'll find out what the court thinks about that soon enough. Then there are petitions filed by Ankita and Kavita and by a couple in Kerala asking for recognition under the Special Marriage Act of same sex partners. And then there's a petition by two men from an Indian citizen in the US and an OCI card holder seeking recognition of marriages registered abroad under the Foreign Marriages Act. So there are these petitions that are pending. And of course, this will transcend really the issue of personal law, because while leaving Abhijit's petition aside, if the Special Marriage Act is construed to include same-sex marriages, then people of the same sex can choose to get married under the Special Marriage Act, even if their own religious laws don't permit them. So this need not entail any tinkering with personal laws. I think it's important to have a recognition of same-sex marriage as a secular idea, and the court's providing for that.
And finally, we're all about leaving listeners with something to really think about over the weekend. Given what we've spoken about so extensively, what is your one message, Saurabh?
How about two messages? The first one is a slightly more lighter message, which is it's not a very expensive book. Go out and buy it. Right? That's message number one. But message number two, which is probably more important and which is something to do with it, is I think it's important for people, and I've said this before, so I'll just repeat it, is for people to become political, for people to become empathetic, for people to put themselves in the shoes of the other to see how that shoe bites, really. I think you have to stand up and fight, not only because you are affected yourself. You have to stand up and fight because it's the right thing to do. You have to stand up and fight because your friends, your family, your cousin, your nephew, your aunt, your uncle deserve the same freedoms that you take for granted. And you need to stand up and fight because we all wish to live in a country where there is justice for all, freedom for everyone, and indignity for none. Because that is the India I hope to live in. That is the India that was promised to me in 1950 when the Constitution was framed. That's an India that is still very, very far away. But I do know, Shivraj, in my heart of hearts, that is an India that we can achieve if we all work together.
Saurabh Kirpal, thank you ever so much for being part of this conversation.
Thank you for having me, Shivraj. It's a pleasure speaking to you always.
Introduce us to similar folks you'd like featured by writing to me at shivraj@brevis.in, or even by sending me a voice message. That's right, we're all about hearing from you. You can send your voice messages on +91 962 547 5442. I repeat, +91 962 547 5442. Or you could also send me your number and I can add you to my subscriber list on WhatsApp. Don't forget to keep a lookout for the next big weekend playlist episode. Have a great weekend and the rest of your week.